Hello, veterans, AKV employees, everybody watching here at Veteran Lang. So glad you're here. So glad. We're always here to make the process smoother between veterans and VA alike. And your friendly VA accredited attorney, Matthew Lang, has another topic. Hey, this topic actually comes from an issue that I have seen and experienced for a number of years with the VA, especially while working within the VA and working as a VA accredited representative or VA accredited attorney. We see this error often and we catch it quite often. It has been continuing on for a number of years now. So I think it's very important to speak on this error, and maybe it's my experience talking, but I feel this is another basic issue that the VA should understand, especially by now. So the VA Office of Inspector General just released, or at least recently released, a report finding that VA claims processors incorrectly evaluate service-connected joint disabilities at 0% about half the time. You got it. I said half. Half the time. Half of the decisions made granting 0% for a joint disability were wrong. And according to the Inspector General, those errors cause an estimated $45 million in underpayments to veterans. Yes, veterans. If the VA is not denying you with the impression of they want you to go away, they are definitely not paying you enough sometimes. $45 million in underpayments to veterans because they did not evaluate service-connected joint disabilities at 0% properly. This was not simply one poorly trained employee at one regional office. No, the Inspector General found confusion among claims processors, confusion within VA's compensation service, unclear language in VA's procedures, and problems with the software VA uses to build rating decisions. This was a problem on all fronts. So in other words, the VA did not consistently understand how to rate painful joints under its own regulation. So today, we're going to discuss what the Inspector General found. We're going to discuss what 38 CFR 4.59 is, what it actually says, and what veterans should look for when VA assigns a 0% evaluation to a painful joint. And it would be in my experience that likely veterans, if you got a 0%, you may want to consider an appeal, especially if half of those decisions are wrong. But again, I'm only here for education. Your facts, your claim may be different, and a 0% may be proper underneath your facts. We're not here to give legal advice on this channel, but if you are looking for legal advice or potential representation, don't forget you've got BSOs, you got accredited agents and accredited attorneys out there like myself. And if you want to talk to us here and myself, check out veteranlang.com, where you can find my calendar. Get on there and we can have a conversation either over the phone or in person, at least in person if you're here in Arizona. If you happen to stumble across langslegal.com, that is our state-focused for Arizona and New Mexico website here at Langs Legal. That will also take you to my calendar. Both the pages are linked together. So one or the other will work if you would like to see if we can help you out. But again, don't forget, PSOs, VA accredited agents, and other VA accredited attorneys are also out there to help you out, veterans, if you so desire the need for representation. All right. On August 6th, 2026, the VA Office of Inspector General released a report titled Review of Assignment of Non-Compensable Musculoskeletal Joint Disabilities. Non-compensable. What does that mean? Well, that means the VA has recognized that the disability is related to military service, but assigned a 0% evaluation. Service connection at 0% is not meaningless, veterans. It's not meaningless. It establishes that the disability is service-connected and it may provide access to certain benefits. But it also says that the percentage assigned at 0% does not produce monthly disability compensation for the particular condition. So keep in mind, veterans, 0% is not meaningless. It could provide access to other benefits, might even give you the opportunity to file an increase in the future. But a 0% evaluation does not produce a monthly disability compensation for that particular condition. And that's non-compensable. Compensable starts at the 10% because it starts providing a monetary amount. Now, the Inspector General examined whether VA claims processors correctly assigned 0% evaluations for service-connected musculoskeletal joint disabilities. Now, these conditions involving the joints are ones such as the knees, the ankles, the shoulders, the elbows, the wrists, the hips, and even the spine. The Inspector General found that claims processors incorrectly evaluated conditions based on painful motion about 50% of the time during the period reviewed. Now, remember, from experience, I have seen this error go on for a number of years. So when we look outside of that period that was examined by the Inspector General, we may find that this could be more of a problem than the 50% they found. So think about what all of this means. The VA had already conceded service connection. The remaining question was the proper evaluation. Yet veterans who may have been entitled to compensation ratings were instead assigned 0% and received no monthly compensation for that disability, which ultimately reached that estimated amount of at least $45 million in underpayments to veterans. So, according to the Office of Inspector General, the errors occurred because VA personnel did not consistently understand how to apply the 38 CFR 4.59. That's the regulation titled Painful Motion. Section 4.59 recognizes that painful motion is an important factor of joint disability. I mean, it's in the title. It states that actual painful, unstable, and malaligned joints due to heel injury are entitled to at least the minimum compensable rating for a joint. But the regulation has generated questions about difference between pain, painful motion, limitation of motion, and functional loss. Those terms are related, but they are not identical. A veteran may be able to move a knee from 0 degrees to the full measured endpoint during a brief examination. Now, that does not necessarily mean the motion was painless. The veteran may experience pain throughout the movement. Pain beginning at a particular point, increased pain after repeated movement, or much greater impairment during a flare-up. A veteran may also be able to force a joint through a measured range of motion in an examination room, but not be able to move the joint normally over the course of a workday. The Inspector General found that claims processors were confused about how to weigh veterans' subjective reports of pain against objective medical findings. They were also confused when pain and without objectively recorded painful motion and may support a compensable evaluation. That confusion was not limited to regional office personnel. The Inspector General found inconsistent interpretations among employees in several offices within VA's compensation service. If I recall correctly, the office that writes the manual. This is a very important part of the report. The people responsible for providing nationwide direction on disability compensation did not consistently agree on how the regulation should be applied. The people writing the guidance didn't know how to apply it. So now we need to be precise. Section 4.59 does not necessarily mean that every mention of joint pain automatically creates a 10% evaluation. The evidence still has to establish the type of painful, unstable, malaligned joint disability contemplated by the regulation. The minimum compensable evaluation also depends on the joint and the applicable diagnostic code. But VA cannot deny a compensable evaluation merely because the veteran demonstrated what the examiner called normal range of motion. Normal range of motion and painless motion are not the same thing. Boy, don't I know it. And so many other veterans know it too. The Court of Appeals for Veterans Claims has also made clear that 4.59 is not restricted only to arthritis claims. The regulation may be applied more broadly when VA is evaluating a musculoskeletal joint disability. The court has further recognized that objective medical evidence is not always required to establish painful motion. A veteran may be competent to describe pain experienced while moving a joint. The court has said this for, I want to say, at least 11 years. Now, that matters because pain is often experienced rather than visibly observed. I don't know, veterans, how many of you out there actually experience pain, but no one else ever knows it because they don't see it? Right? If not all of us, many of us. So that's what the VA's got to remember. One thing, anyways. An examiner can measure the angle of a knee. The examiner cannot directly measure the veteran's personal experience of pain the same way. That does not mean VA must accept every statement without evaluating its credibility in the entire record. Don't freak out on me, VA. It means VA cannot treat competent lay evidence as though it has no value merely because it is not accompanied by particular objective test results. At the same time, pain by itself is not automatically equivalent to functional loss under every rating provision. VA must examine how the pain affects motion and the veteran's ability to use the joint under the ordinary conditions of life and work. The correct analysis is more detailed than simply asking, was the range of motion normal? VA should be asking this: was the motion painful? At what point did the pain begin? Did repeated use cause additional limitation? What happens during flare-ups? Does pain affect standing, walking, lifting, reaching, gripping, sitting, climbing stairs, or performing other ordinary activities? Is the joint unstable? Is there weakness, fatigability, lack of endurance, or incoordination? And does the evidence support at least the minimum compensable evaluation under the applicable diagnostic code and 38 C.F.R. 4.59? Those are the questions to be asking. Not, was there an objective test that shows painful motion? Now, the OIG's report, the Office of Inspector General's report, also highlights why the wording of a VA examination is so important. Suppose a veteran attends a knee examination. The examiner records flexion and extension that do not satisfy the ordinary criteria for a compensable evaluation based strictly on limitation of motion. If the analysis ends there, the VA may assign a 0%. But suppose the same examination also states that the veteran experienced pain during flexion, had pain with weight bearing, or experienced functional impairment after repeated use. That information may change the rating analysis. The veteran may report flare-ups during which the knee swells, becomes painful, or limits walking and standing. The examiner should attempt to estimate the additional functional loss during those flare-ups based on all procurable information, including the veteran's description. An examiner should not disregard that information simply because the examination did not occur during a flare-up. The rating specialist, the decision review officer, must then consider the entire examination and the other evidence of record. We've heard this before, right? You must review all of the evidence and consider all of the evidence. The rater or even the DRO should not extract one measurement and ignore the rest of the report and declare the disability non-compensable. The Inspector General found that claims processors did not consistently review and weigh both subjective and objective evidence properly. We see this in pretty much all decisions we see back here. The weighing of evidence and the reviewing of evidence seems to never be done properly. This is not a minor technical problem. It may determine whether the veteran receives compensation at 0%, 10%, or potentially a higher percentage. The Inspector General also examined VA's evaluation builder tool. Yes, the evaluation builder tool. The one that VA is trained to rely on without thinking about what the criteria is in the C.F.R. most of the time in order to assign an evaluation. So this is software. So it makes more sense. This is software that is designed to help claims processors select an evaluation and construct the language used in a rating decision, even though it's not always used that way, from experience. A tool like that can improve consistency when it actually reflects the law. But it can also spread errors when it prompts or its terminology is confusing. The Inspector General concluded that aspects of the evaluation builder contributed to inconsistent decisions. One of its recommendations directs the VBA, Veterans Benefits Administration, to determine what changes are necessary to reduce confusion and ensure consistency for musculoskeletal conditions. I know the law. Don't rely on the tool that's been broken since day one. That's from experience. That evaluation builder, we were told, was never to be fully relied on. It's a tool to assist, but you must confirm with the rules and the laws and the regulation, and especially the C.F.R. and the rating scheduler, before assigning the evaluation to ensure the tool is correct. As they always told us, trust but verify. Ultimately, the point here is if the tool does not properly prompt the rater to evaluate or the DRO to evaluate painful motion, lay evidence, repeated use and functional impairment, favorable evidence can definitely be missed. But it shouldn't. It's there to assist, not to replace. Now, VBA reported in March 2026 that it had corrected all the individual errors identified by the Inspector General by February of 2026. Now, that's good for particular veterans whose cases are identified, but it's not completely resolving the larger issue. The Inspector General made 4 systematic recommendations. First, VBA should consult with the VA's Office of General Counsel and establish a clear, consistent interpretation of 4.59, including whether pain alone without painful motion supports a compensable evaluation. Talk to those who are trained in the law to actually provide the guidance or provide guidance to the guidance instead of having lay people tell you how to interpret the law. It's an interesting concept. Second, VBA should consider revising its adjudication procedures manual after obtaining that legal interpretation. So don't just go out and on a whim change your manual without knowing what you're writing. I like that idea too. Third, VBA should determine whether claims processors have clear guidance about reviewing all evidence and properly weighing subjective and objective evidence. Training. Good training, proper training. I like that sound of that too. Very important, education. Education. I'm a big proponent of education and training. Fourth, VBA should determine what changes are necessary to its evaluation builder tool. As of the report's publication, all 4 recommendations had remained open. So while VA says it corrected the specific cases found by the Inspector General, the underlying problems with legal interpretation, guidance, evidence review, and rating software had not been fully resolved. So if you have a service-connected joint disability, veterans rated at 0%, this report does not automatically prove that your rating is wrong, even though you may likely have a wrong rating. But it provides a very good reason to review the examination and rating decisions carefully. Start with the VA examination. Look for statements concerning pain during range of motion testing, pain with active or passive motion, pain during weight bearing or non-weight bearing, functional loss following repeated use, flare-ups, weakness, fatigability, lack of endurance, organ coordination, instability, and interference with standing, walking, sitting, lifting, reaching, gripping, or other activities. Then review the rating decision. And ask yourself, did VA acknowledge the favorable findings? Did it discuss painful motion? Did it explain why 4.59 did or did not support the minimum compensable evaluation? Did it consider your own statements about symptoms and functional impairment? Or did it rely almost entirely on the fact that the examiner recorded what VA considered normal range of motion? Also pay attention to whether the examiner accurately recorded what you reported, veterans. We do see that as an error fairly often as well in the VA's examinations. Now, if you told the examiner that your knee becomes significantly worse after walking or during flare-ups, but the examination report says you denied flare-ups or functional loss, that discrepancy could be very important when it comes to deciding your claim. So veterans should describe their symptoms accurately and specifically. Do not simply just say my shoulder hurts. Explain what causes the pain, when it begins, how often flare-ups occur, how long they last, and what activities become difficult or impossible. Now, if VA recently assigned a 0% and the decision is still within the appeal period, veterans, the appropriate review option will depend on the evidence and the nature of that error. Supplemental, higher level review, notice of disagreement to the board. You may find the higher level review may be more appropriate when the evidence needed to demonstrate the error was already in the record, and the argument is that the VA misapplied the law or overlooked favorable evidence. Supplemental claim you may find appropriate when additional relevant evidence is needed. An appeal directly to the board may be appropriate well in other circumstances. I tend to go there when I know the whole claim is together and I haven't found the right DRO or the right RBSR to properly interpret the rules and regulations, because at least I know I stand a better chance with legal professionals and their interpretation. But that's just me. You may find it different, veterans. But ultimately, that correct lane and that correct appeal is going to depend on your particular case, veterans. So don't just select an appeal option based solely on any just general guidance. Understand the rules, the regulations, look at the evidence, and make that determination. Or again, work with your accredited representative to have them help you with that as well. So the central lesson from this report, I think, is simple. A joint does not have to be frozen in place before it becomes compensable. A veteran may demonstrate a technically normal range of motion and still experience painful motion. Flare-ups and repeated use limitations, instability, and functional impairment, and all the other good things we talked about. But yet, the VA, half the time, is still processing claims incorrectly when it comes to evaluating non-compensable joints and painful motion of those joints, which again, the Office of Inspector General has estimated $45 million in underpayments to veterans. So veterans, make sure you get the right help. Make sure you double check the VA. If you need some training assistance, I'm here for you. I really am. I think this is, again, something that feels very basic. And again, that can be my experience. But VA, you got to understand your rules, your regulations. If you're just going to click buttons, well, we got AI to do that for us now. And I would really hate to see it replace you. I really feel that the human element that understands the rules can make the interpretations, the judgment calls as necessary when it comes to VA benefits. So until next time, veterans, VA, both stay informed. Veterans, protect your claim. VA, Do not just assume that because the examiner said so is enough. Review all the evidence, weigh it all, understand the rules. And let's make the process smoother between veteran and VA alike. I will wish you another tremendous, terrific day. I'll see you in the next video. Thank you.